We are delighted to have Colette Rutel here to talk about United States v. Cooley.
Thank you. Thanks for having me here. My name is Claire Rutel, and I'm a professor of law and co-director of the Native American Sovereignty Institute at Mitchell Hamlin School of Law. And I'm going to talk with you today about United States versus Cooley, which is a decision that the Supreme Court handed down in June of this year. My sense from looking over the participants is that most of you do not practice federal Indian law. And so I'm going to spend a lot of today kind of giving you the background of the legal area and a description of the case under the impression that probably many of you have not reviewed this case or the briefing, listened to the oral argument, but certainly I am happy to entertain advanced questions related to the case for federal Indian law in general. So hopefully everybody will just chime in the chat as you have questions when we're moving through this. So I want to start with the facts in United States versus Cooley. I think it was an interesting factual case. There was a truck that was parked on the shoulder of a U.S. highway that ran through the Crow Reservation. The car's engine was running. It was 1 o'clock in the morning, and a tribal police officer named James Saylor saw the truck. And his initial reaction was not that there was a crime occurring. It's an area of the roadway that people commonly pull over if they're tired. There is not great cell phone reception. And so the truck had Wyoming plates. So it had, the Crow Reservation is in Montana, so it had out-of-state plates. And so he approaches the vehicle thinking that he's going to make sure that the occupants are okay, that they don't need to change a flat tire or need other assistance. When he walks up to the truck, he asks the occupant if they're okay and gets a thumbs down from the person in the driver's seat, and then he asks them to roll down the window. And when he does that, he notices that there is a small child who's in the back seat who's starting to crawl into the front seat and sit on the driver's lap. The driver appears to be non-Indian, is one of the first observations that he makes. And has bloodshot eyes. But at this point, the officer is not thinking that he's under the influence in any ways. He's thinking that maybe he's tired. And that's what the driver confirms to him. He says, "I'm tired. I just pulled over to the side of the road to get a little bit of rest." But the officer asks a few follow-up questions that really muddy the waters, if you will, because he asks the driver where he was coming from, and the driver indicates that he was coming from Lame Deer, which is only about 30-minute drive away. So not a far drive. You wouldn't expect somebody to be leaving Lame Deer at 12:30 in the morning and already tired by 1 a.m. And then the driver gives him a story claiming that he bought this car from somebody in Lame Deer. And he gives two different names, one of which is a known drug dealer. The other one is a probation officer. But there are a bunch of personal belongings strewn throughout the car. So the officer now is suspecting something's going on. And he can see that there are two rifles on the front seat of the car that are clearly visible to him. And he asks to see the driver's license at that point. And this is when the confrontation escalates. According to the police officer, the driver starts to kind of stare off in a way that makes him think he is going to use violence of some sort. So the police officer pulls his gun and asks him to keep his hands on the steering wheel. And as it turns out, there was a loaded handgun that was right near the driver's side, his right hand, which was making a move that the tribal police officer thought he was moving for. So at that point, he ushers him out of the car. He does a pat down. He finds some drugs in his pockets. He calls for the FBI to come to the scene while Mr. Cooley is secured in the police vehicle. They go back and do a plain view search of the car and find additional weapons and drugs. And so the question here that was presented in federal court. So he's not tried in tribal court, and I'll come back to why that is in a second. He is charged in federal court, and he's charged with possession of methamphetamine with an intent to distribute, and possession of a firearm in furtherance of drug trafficking. And his attorney moves to suppress the evidence, saying that it is an unlawful search and seizure because the tribal police officer had no authority to conduct the stop, to detain him, or to conduct the search. And the district court granted that motion, and the Ninth Circuit affirmed and ruled that the search was and detention was invalid and excluded the evidence. And then the US Supreme Court took the case. In terms of what the US Supreme Court was reviewing, the Ninth Circuit's decision said that tribes don't have criminal authority over non-Indians, and we'll see that that's not a new decision. The Supreme Court has previously held that in a famous case called the Oliphant versus Suquamish tribe from 1978. The court pointed out that the activity in question happened on a US highway, and so the tribe wasn't a landowner, and they don't have the landowner's right to exclude. So the only thing they could rely on was their sovereignty that the tribe has, their inherent sovereign authority. And the Ninth Circuit said you don't have that authority over non-Indians who commit crimes on the reservation. So according to the Ninth Circuit, you could only briefly detain non-Indians. And there was sort of a two-part test the Ninth Circuit developed. First, you had a very brief period of time to determine whether the person was Indian or non-Indian, because the tribe does have the authority to prosecute Indians. And once you were able to very quickly determine that the person was a non-Indian, then you could only detain them or conduct a very brief search if there was an apparent or obvious violation of state or federal law, which is higher than a probable cause standard. So why did this matter, and why did the Ninth Circuit uphold the motion to suppress under these facts? It's, if you recall the facts that we were talking about, the police officer didn't stop the car thinking that there was a crime in process. When the driver initially rolls down his window, the police officer quickly, and we can talk about whether you can actually do this in most scenarios, but quickly came to the conclusion the driver was non-Indian, and did not think, just from the fact that he had bloodshot eyes, that he was under the influence in any way, assumed that he was tired. And so at that moment, the Ninth Circuit says he should have walked away, ceased to continue to engage and ask additional questions. He shouldn't have been asking for a driver's license, et cetera. And so there was no apparent and obvious violation of state or federal law, according to the Ninth Circuit. So this case went up to the US Supreme Court. I'm going to start, a little curiously with laying out the respondents' arguments in favor of affirmance, and then I'll come back to what the United States was arguing, since they were doing the prosecution. The Crow tribe also participated in this case through an amicus brief, and there were actually a number of amici that submitted briefs to the US Supreme Court. The argument on behalf of Mr. Cooley, tracked pretty closely what the Ninth Circuit had done, but fleshed out the parameters in terms of tribal jurisdiction a little bit more, which is what I want to talk about. So Mr. Cooley's attorney noted that this is on a right of way. This activity happened on a right of way. Yes, it was within reservation boundaries, but as a result of that, there is no right to exclude as a landowner. And so the power that the tribal police officer was exercising had to come from the sovereign rights of the Crow tribe. The respondent pointed out that the officer immediately knew that he was not Indian. Federal authorities arrived quickly. There wasn't an obvious and apparent violation of federal or state law. And so, tribal authority normally doesn't extend to search and seizure under these cases. And what they were relying on are these general principles of federal Indian law. So the first thing I'll say in terms of principles of federal Indian law is that we usually consider tribes to be territorial sovereigns. So within their reservation, to simplify things, they have all powers of inherent sovereignty. And that's represented by the circle on the screen. But those sovereign rights could have been restricted by a treaty, so an agreement entered into between the tribe and the United States, or they could have been expanded by a treaty between the tribe and the United States. And so to give you an example, there were some treaties, and there's a treaty involving the Crow tribe that we'll talk about in a little bit from 1868, where the tribe explicitly said that the United States had the right to prosecute certain crimes that were committed against Crow tribal members within Crow territory. So that might be the tribe relinquishing some of its territorial authority. So the bite out of this circle. And likewise, there are many treaties that say tribes have the authority to hunt, fish, and gather off reservation outside of their territorial jurisdiction. So that could be a treaty expanding the inherent authority of the tribe. In addition, you have statutes that can do the same thing. So a statute can expand the authority of the tribe as inherent sovereign or take away some of that authority. So, so this is, the treaty is the executive branch making adjustments, statutes is Congress making adjustments, and there are many examples of both of these. The important thing is that in 1978, in the decision of Oliphant versus Suquamish tribe, the court created a new restriction on tribal sovereignty, which is known as the implicit divestiture doctrine. To the court, and this only goes one way, the bite out of tribal sovereignty, it only takes sovereign powers away, it can never expand it. The court decided as a matter of federal common law that when tribes were incorporated into the United States, probably at the moment of discovery, according to the US Supreme Court, they lost certain sovereign authorities that the court said were inconsistent with their status as domestic dependent nations. And so one of the first case that set this out was Oliphant versus Suquamish tribe, which is very relevant here to the United States versus Cooley. It's a modern case. It's decided in 1978. And this is the first time the Supreme Court articulated this implicit divestiture doctrine. And it decided that tribes do not have criminal jurisdiction over non-Indians. So even if a non-Indian is committing a crime within reservation boundaries, the US Supreme Court has said that tribes no longer have the authority to prosecute those offenses. Now, one thing for those of you who practice in this area or know a little bit, you might say, wait, there are some examples. And there are some examples today where tribes can prosecute non-Indians for crimes committed within reservation boundaries. And in particular, it's in the domestic violence realm. That's because Congress passed a statute called the Violence Against Women Reauthorization Act in 2013 that explicitly says tribes have authority to prosecute certain domestic violence related offenses. So that's Congress, again, altering this structure through a statute. But the Supreme Court said without that affirmative act of Congress, tribes have lost this authority to prosecute non-Indians. And the first time it said that was in 1978. The next criminal case that the Supreme Court decided is this case called Duro versus Reina in 1990. And here the court was presented with the prosecution by a tribe of a non-member Indian. That's the way we refer to it. And it doesn't, that using that language doesn't really make sense. So I'll describe what it means. If you're a member, for example, of the Shakopee, Mdewakanton, and Sioux community here in Minnesota, but you're on the Mille Lacs Bands reservation, so you're on a different tribe's reservation, and you allegedly commit a crime, you are considered in that scenario a non-member Indian. You're not a member of the tribe whose reservation you're on, but you are actually a member of another federally recognized tribe. So you are considered Indian legally. And the US Supreme Court in the Duro decision decided that it was going to extend Oliphant to non-member Indians, and that tribes could not prosecute non-member Indians for crimes within Indian country. Well, here Congress stepped in again, and Congress said, no, that's not right. We don't think that this was divested by federal, by any action that we took, and we think tribes retained it after discovery. And so Congress passed what's known as the Duro Fix, which is part of the Indian Civil Rights Act. Again, going back to this, Congress has the authority to do that, to restrict or expand tribal sovereignty. Here, what Congress was doing was loosening the restrictions. So it wasn't granting the authority. It was just saying, no, if there was any restriction on this sovereign authority, we're loosening the restriction. And I can talk about the reason for that if anyone has questions about it. But those are the only two criminal cases. And so based on Oliphant and Duro, in the criminal context, we have pretty bright line rules. Tribes cannot prosecute non-Indians for criminal offenses. The tribes can prosecute all members of their own tribes or members of other federally recognized tribes for crimes within Indian country. And so you can see now how the respondent was arguing in this case. We should uphold the Ninth Circuit's decision. My client was non-Indian, and the tribal police officer knew right away that he was non-Indian, and as a result, the tribe didn't have authority over him. There's also an interesting line of cases that I have up here, and I've only listed some of them in red, that continue this implicit divestiture doctrine into this civil context. And here it was picked up for the first time in this case called Montana versus the United States. This was a case that once again involved the Crow tribe. And here it was about the tribe's ability to regulate hunting and fishing on its reservation, particularly on fee land that was owned by a non-Indian. Could the tribe say to that non-Indian, you cannot hunt and fish on your reservation? And the Supreme Court said no. And in this decision, the court said the general rule is that tribes do not have jurisdiction over non-Indians within Indian country, so within tribal reservations. There are, and said that this was because of the implicit divestiture doctrine, because tribes, when they were incorporated into the sovereignty of the United States, somehow lost this power. The Supreme Court did create two exceptions in Montana, which are going to be very important to United States versus Cooley. The first one said if there is a consensual relationship between the tribe and or a tribal member and this non-Indian that we're talking about, the tribe may have authority to regulate or adjudicate a dispute between those parties. The second exception was about impacts to the tribe's political integrity, economic security, or health, safety, and welfare. So the general rule was in civil context, tribes cannot exercise authority over non-Indians, but there were two exceptions. In the later cases, the court in Strait versus A1 Contractors, Devon versus Hicks, and Plains Commerce Bank, and a number of other cases, the court really limited the operation of those two exceptions. And in fact, the court had, prior to United States versus Cooley, never found the second Montana exception satisfied. So this is all meant to, I'm going to go back a little bit and say, to explain how the respondent was saying, look, the tribal police officer doesn't have authority here to detain my client, to ask questions of my client because this is a criminal case, and Oliphant says he's not Indian and there's no authority over him. In addition, there were arguments that were raised at the Supreme Court level about a Crow Treaty that I'm going to talk about in a little bit, and the respondent said the Crow Treaty doesn't apply. And the respondent also cited those civil jurisdiction cases and said, look, I mean, this shows that the tribe doesn't really have authority over non-Indians. And while we think those cases are largely irrelevant, they, if they were to apply, they wouldn't apply in this situation. So then we go over to the petitioner's argument. So again, this is the United States, and this is one of the interesting things about a lot of Indian law cases when tribal sovereignty is at stake and big issues for Indian tribes and for Native people. Unfortunately, tribes and Native people often aren't the parties in the litigation. And here, because we're talking about a federal criminal prosecution, it's the United States that's the petitioner, that's the party, and no tribe, it's a criminal case, so you can't have intervening parties. So the Crow tribe wasn't a party, like I mentioned before, it was an amicus and submitted an amicus brief, but the party here, the principal party here is the United States. So the United States argues that the Ninth Circuit's decision needs to be overturned. And they point to a bunch of dicta in some of these cases where the Supreme Court seemed to indicate that fine, tribes were limited in their ability to prosecute, but they weren't limited in their ability to initially stop, detain, question, etc. And granted, it was all dicta, but there are some isolated pieces of in each one of those civil jurisdiction opinions that leads you to believe the court thought tribes had this authority. The United States and amici really highlighted the historical practice that fine, if tribes lost this authority, supposedly at the moment of discovery, then we wouldn't see tribes exercising the ability to question, detain, exclude non-Indians from reservations in the 17 and 1800s. If we see that action on the ground, the United States and amici argued, this shows that tribes retain that after discovery. And so there was a lot of information in amicus briefs and in the United States principal brief that said this is an historical practice that has gone on. It was not implicitly divested. The United States also points out that there's no reason for the court to find that it was somehow lost because tribes should have this power and it's not inconsistent with their status as domestic dependent nations. And in particular, the United States drew a distinction here that the Supreme Court really eventually picks up on. And the distinction that the US drew is that the tribal police officers' actions are not going to lead to a prosecution in tribal court because of Oliphant. So we don't have to worry about, is the tribal court going to apply tribal laws that this defendant had no ability to participate in the adoption or participate in its writing or adoption, or are they going to be subjected to tribal court proceedings where maybe the Bill of Rights doesn't apply? So the court, the United States asked the court to recognize that this was a unique situation where we weren't talking about the tribe then exercising adjudicatory authority over Mr. Cooley. They were going to be just turning Mr. Cooley over to federal or state authorities. And so his rights weren't really limited in any significant way. Interestingly, the United States argued, and I think no one really doubted this argument at the time, that Montana did not apply. That the Montana case was about civil regulatory and civil adjudicatory jurisdiction. And this really was about executive action, the executive action of tribal police officers. And so the court hadn't specifically addressed this before. It had in dicta said that it was that this practice was something tribes had the authority over. And so the United States argued Montana didn't apply. There was another argument, though, that was made by the petitioner and by several amici that was tribe specific, basically giving the Supreme Court an out to rule in just this case involving the Crow tribe if they didn't want to address broader issues that would apply to all tribes. And that is the Crow tribe in the United States negotiated a treaty together in 1868. And that treaty has a clause that can be found in several treaties that were negotiated with tribes around the same time period. And the treaty clause is referred to as the bad man clause, which you can see why if you read it here. The idea was that there were a number of US settlers, soldiers, et cetera, who were engaged in criminal acts against tribal members. And that this would at times cause tribes to go to war with the United States. And so the United States wanted to prevent that from happening by assuring tribes that they would prosecute any wrongdoers who were committing crimes against tribal members. And this language in the treaty clause then says that if bad men among the whites, commit these crimes, upon, and the important part is in bold here, upon proof made to the agent and forwarded to Washington, D.C., then the United States is going to arrest and punish them for the offense. So the argument that was made here in the petitioner's brief, as well as in several amici briefs, was that to be able to provide proof that a crime has been committed, the tribe must have authority to briefly detain and question and search non-Indians within their limits. And then as a result, they have certain investigative powers and they can turn over that evidence then to the federal agent who can decide to prosecute the non-Indian. And so that was one of the arguments that was made by the petitioner. So we're finally now to the decision. The decision, shockingly, was a 9-0 decision in favor of reversal of the Ninth Circuit's decision, so upholding the tribal police officer's authority. And I guess I should say, shockingly, depends on who you are. I was pleasantly surprised. There was at least one Indian law professor, Matt Fletcher, who predicted this before the decision came out, and so he's looking pretty good right now. The court, and I'm going to flesh this out a lot more, and hopefully at some point you'll have comments or questions about this. But the court notes that the Ninth Circuit standard that they created was new, it was unworkable. And then very interestingly, the court decides to rely on Montana's exceptions, in particular the second Montana exception, to uphold tribal sovereign authority. And so that's the piece that has really important implications, I think, for Indian law moving forward. So why was it interesting? When you listen to the oral argument, and I only provided very few excerpts here over the particular issue of does the second Montana exception apply here, the justices were a little bit all over the place in their questions, and they seemed to, at least during oral argument, it almost seemed to be that the court was concerned. It was trying to find a way to uphold tribal authority here. But it didn't seem like the second Montana exception was appealing. At the outset of the oral argument, Chief Justice Roberts is asking the attorney for the United States why Montana would be helpful, and said, after Montana, tribal sovereignty over non-members cannot survive without express congressional delegation. And so was saying to the United States attorney, tribes don't have inherent authority over non-members. We already somehow decided this really broadly, is the way that he was characterizing Montana. More troubling than that really was Justice Sotomayor, who, if you follow Indian law cases, Justice Sotomayor is the consistent vote for tribal sovereignty in Indian tribes in the US Supreme Court since her appointment, despite having very little exposure to this area of the law prior to her appointment to the US Supreme Court. So during questioning, again, she was talking to the United States' attorney, and said pretty flat out, I'm not sure that this fits the second Montana exception. And so again, just to go back, if I can, the Montana rule, which comes from this case involving civil jurisdiction and in particular hunting and fishing on the Crow Tribes reservation, the general rule is that tribes don't have authority over non-members in civil, regulatory, and adjudicatory contexts. The second exception, though, said a tribe can retain that power if the conduct threatens or has a direct effect on the political integrity, economic security, or health and welfare of the tribe. And you read this, and if you don't practice in this area, you think, well, of course that applies. I mean, you're talking about somebody who's engaged in potentially criminal activity on the reservation. That seems to fit this requirement that tribes can regulate if it has an effect on health or welfare. But the Supreme Court, in the series of cases that followed Montana, really limited that exception. So in Strait versus A1 Contractors in 1997, the Supreme Court was looking at a car accident that resulted in a fatality on an Indian reservation. And the court said, even though a tribal member had died in the car accident, a civil wrongful death action couldn't be brought against a non-member in tribal court. And basically said, if the death of one tribal member is enough to fulfill the second Montana exception, the exception would follow the rule. And since then, the court has never gotten to a point where it's found that the second Montana exception is satisfied. Instead, it's used increasingly heightened standards for this exception, and said that the conduct really has to imperil the health, safety, and welfare of the tribe, or it has to have potentially catastrophic effects. And so it's certainly the second Montana exception has been viewed as a very high bar in terms of when tribes can exercise authority under that exception. So it wasn't surprising during oral argument that Justice Sotomayor seemed a little bit skeptical of that. And I think most people were thinking, well, that's okay, because Montana is just about civil, regulatory, and adjudicatory authority. We're not really talking about that here. We're talking about a tribal police officer. And maybe we can get this in under it's an executive action. It's criminal in nature, but it hasn't been divested from tribes the way the United States argued it. Justice Roberts did indicate, though, I mean, interestingly enough, when the respondent's attorney was arguing, that he might have actually seen this as the approach. And so it leads one to wonder whether, even though the decision was written by Justice Breyer, whether it's Justice Roberts who found this sort of middle ground that all of the justices were able to agree on, even though somebody like Justice Sotomayor wasn't initially thinking about the second Montana exception, because he raises during oral argument, he said, I wonder why it doesn't apply here. It seems like, basically there's nothing that would satisfy this exception more than criminal law cases not being able to protect the public from crimes that are in progress. And that is exactly what the court decided. So in a 9-0 decision, the court decides that the tribal police have this authority to initially stop and question even non-Indians for crimes that they think might be committed on an Indian reservation. So they basically have Terry stop authority. And they uphold this under the second Montana exception, saying that the present case fits almost like a glove, which it seems like that comes from Chief Justice Roberts from his discussion with counsel during oral argument. And the court uses a lot of the same arguments that came up during Chief Justice Roberts' exchange with the respondent's counsel, and specifically says, look, this doesn't make any sense. If you pull over someone who you think might be intoxicated as a tribal police officer, you should be able to do enough inquiry to figure out if they are intoxicated, even if they are non-Indian, and then detain them and turn them over to state or federal officials, even though you can't arrest them themselves. Otherwise, as the court says here, allowing a known drunk driver to go back to the car and drive down the road could endanger the health or welfare of the tribe. And so that's why it fits the second Montana exception. The court, though, I think, explained why it saw this case as different from a lot of the other cases in the line of civil jurisdiction, where it had previously construed the exceptions rather narrowly. So the court highlighted that in this case, and the United States had pointed this out, in this case, we're just talking about the tribal police officer's authority to engage in this Terry stop. And the non-Indian will never be prosecuted in tribal court, and tribal law will never be applied to him or her. They would only be prosecuted in state or federal court. And so they have the ability to participate in state or federal politics in the legislative process, and they're protected by the Bill of Rights in state court and in federal court. And so a lot of the concerns that led the court to restrict tribal sovereignty over non-members didn't apply here, according to the Supreme Court. And even though the court put this sort of towards the end, it seemed like this was an important point, that the Ninth Circuit's standard here was really unworkable. So under the Ninth Circuit's rule, the tribal police officer would have to pretty quickly determine whether somebody was Indian or non-Indian. And interestingly enough, the tribal police officer in this case just kind of made a very quick determination by looking at the driver and said, oh, he's not Indian. And he was right in this case. But for those of you who don't practice in this area, whether you're considered Indian as a matter of law is typically, but not always in criminal jurisdiction, is typically based on whether you're an enrolled member or citizen of a federally recognized Indian tribe. And every tribe has a different law for who can qualify for membership. Some tribes require a particular blood quantum. Other tribes don't and require you to trace your ancestry to a particular role that may have been created, for example, in the late 1800s. And so there are some tribes where citizens can be enrolled in the tribe with what we would consider to be very low blood quantum that may look to somebody as though they're non-native, but they are considered Indian by the tribe, by the federal government, and for all legal purposes, they are a citizen of a tribe. And what's really important is in most of Indian law, this is the basis for most of Indian law because we consider this to be not a racial classification. It's a political classification. It's based on your citizenship in a federally recognized tribe. So it's akin to being a US citizen or being a state citizen. And it's a political classification, not a racial classification. And, so the reason why this would be so hard to determine, even if we're just talking about tribal citizenship, is there are more than 560 federally recognized tribes in the country. So it's not as though the tribal police officer could just say, what's your name? And then check against a list of enrolled Crow members. The person who's on the reservation could be a member of any of those 560 plus federally recognized tribes. And in fact, there usually are many members of different tribes living on another tribe's reservation, certainly visiting another tribe's reservation. So even just when we're talking about tribal citizenship, it would be hard to make that determination, and certainly something that you couldn't tell by just looking at someone. Additionally, the waters are quite muddy when it comes to criminal jurisdiction, and most federal courts of appeals have concluded that the federal government and likewise the tribes can prosecute individuals who are not enrolled tribal members, but for some other reason are considered to be Indian. They have some Indian blood and they're receiving services from either the federal government or the tribe because they're recognized by the community as being native, even if they don't fulfill the citizenship requirements. So it's actually quite difficult, even in litigation, to determine whether somebody is native or not native under these standards. So the idea that you could just tell on the side of the road by somebody rolling down their window and you could look at them, or you could just ask them the question, it would be very hard to say that. As the opinion states here, if all you're doing is asking, are you Indian, right? There is obviously an incentive to lie as well too. There's no reason that we should expect that the defendant would truthfully answer that question, even if they knew this long definition of what's considered to be Indian under the law. In addition, after you get through that piece and decide that the person was non-Indian, then the Ninth Circuit said you could only go ahead and continue to question them and to use your authority to search or detain them if they're violating state or federal law in an apparent and obvious way. And this is a new standard that the Ninth Circuit created. The court said that it was higher than probable cause, but so obviously it's higher than reasonable suspicion, higher than probable cause. We don't know exactly what it means. And the US Supreme Court was worried that this would result in the proliferation of lawsuits because there are a large number of non-Indians that live on Indian reservations, and this issue is likely to come up again and again and again because the Ninth Circuit's test was really unworkable. Justice Alito had to, he joined in the main majority opinion, which is quite short. So if you're interested in it, you can read it. It's only a few pages, unlike most US Supreme Court cases. And Justice Alito decided he would submit a 1-paragraph concurrence. And basically you can summarize that by saying, wait, it's really narrow. This is really narrow. Just to let everybody know, he says, this is only a decision that says tribal police officer can stop a non-Indian motorist if the officer has a reasonable suspicion that they have or may violate federal or state law. They can conduct a search if it's necessary to protect themselves or others. And if they have probable cause, then they can detain them for a period of time that's reasonably necessary for the non-tribal officer to arrive on the scene. So Justice Alito just trying to say, I think this decision is very narrow and shouldn't be read any more broadly than that. But of course, the last thing I'm going to leave you with is, can we draw anything broader from the decision in the United States Cooley, and what might its importance be? So, interestingly enough, tribes are winning now in the United States Supreme Court for the first time in a very long time. I remember back early, I've been teaching now for 14 years, I think, full time. And been an attorney for some 20 years. And at the beginning of my career, I remember that the late David Getchys, who's dean at University of Colorado's law school, wrote this article and then did a series of talks about the fact that tribes and tribal interests lost in the Supreme Court more than any other group, including criminals. And he had done all the statistical analysis to show that over the past 30 years, tribes and tribal interests were consistently losing more cases than any other category. And so the outlook was pretty bleak for folks that were in favor of tribal sovereignty and that were in this field. But in recent years, there seems to have been a shift now on the Supreme Court, and in some ways, in a surprising way, as the court has shifted more conservative in terms of the justices that have been appointed. The start of this shift happened a few terms ago with a case called Washington versus United States, which was a case involving off-reservation fishing rights in the Pacific Northwest. And in particular, whether the state of Washington was violating treaty rights by not immediately removing barriers underneath bridges and roadways that were preventing salmon from swimming upstream. So when these bridges and roadways were constructed, no one was really thinking about fish passage. And as a result, entire lines of salmon were eliminated from certain rivers in the Pacific Northwest, and the tribes argued this was a violation of their treaty. The Ninth Circuit agreed with them, and then the case went up to the US Supreme Court, and there was a 4-4 split. So the court was not able to reach a decision. If you say, why was there 4-4 when there were 9 justices? Justice Kennedy had to recuse himself and didn't realize that until the case was already pending and briefing had started in the Supreme Court. He actually worked on a predecessor case when he was a judge on the Ninth Circuit way back in the early 1980s, which you can understand why he might have forgotten that then he couldn't hear this case in the US Supreme Court several decades later. But when he recused himself, that ended up in a 4-4 split, which affirmed the Ninth Circuit's decision, which was obviously not precedential for tribes outside of the Ninth Circuit, but was a big victory there. In Upper Skagit Tribe versus Lundgren, this was a case that involved tribal sovereign immunity and whether tribal sovereign immunity extended to tribal property. That is, could you bring an in rem lawsuit against tribal property and get around sovereign immunity? And the Supreme Court said no in that case. And then you have Washington State Department of Licensing versus Cougar Den, which was another treaty rights case. It involved whether the state of Washington can impose a tax on gasoline that was imported from Oregon into Washington and onto the Yakima Reservation. And here the Supreme Court read the treaty pretty broadly and said that it did not, that it protected against this tax. And I see there's a question here. I'll try to stop and read it. What about the scope of the search in this particular case? The decision barely touches on deputization, but aren't there some issues? Okay, yes, so I'll come back to that in a minute. Herrera versus Wyoming is a case that involved tribal treaty rights again, and the ability to hunt for the Crow tribe to hunt off reservation in Bighorn National Forest. McGirt versus Oklahoma, a lot of you may know, is a treaty rights reservation boundary case. It was very big, that came out a little over a year ago now. It involved the Creek Nations Reservation in Oklahoma and confirmed that the boundaries of that reservation remain intact. And then we have United States versus Cooley in this term. So there have been several cases in a row in recent years that confirm tribal sovereignty. What can you take away from those cases, though? I still want to be a little cautious here in saying that if you notice, the pattern is that up until United States versus Cooley, the pattern has been really predominantly about treaty rights and the court's sort of broad reading, using the Indian canons of construction, reading treaties broadly, and narrowly construing any statutes that could be deemed to abrogate those treaties. So it's why Cooley, I think everybody looked at this and said, wow, this is really important, because it's one of the only cases recently that's about tribal jurisdiction that did not rely on a treaty. And remember, they could have relied on the 1868 treaty in this case and decided to render a decision that was broader than that, even though Justice Sotomayor in her questioning indicated that she actually wanted to maybe use the 1868 treaty here. In terms of that question about cross-deputization, and that's my bullet point number 2 over here. One of the things that was argued by the respondent during oral argument is court, you don't have to worry about all of these hypos that you're throwing out there, because during oral argument, not surprisingly, a number of justices were toying with the respondent's counsel a little bit and said, well, what if you have a serial killer that's on your reservation? Are you really telling me that a tribal police officer can't stop the serial killer and can't detain them until federal or state? They just have to watch them drive off? Of course, if you're the respondent's attorney, the answer to that question is no, but you're trying to figure out legally how you can say, no, we can detain the serial killer, but we couldn't detain, Mr. Cooley in this case. And one of the things that the respondent tried to argue in briefing and in the court was, look, the solution to all this is cross-deputization agreements. That is, tribes normally enter into agreements with states or with the federal government where tribal police officers are cross-deputized. So what that means is, under the agreement, they may be wearing the tribal police officer hat at a moment, or if they pull over a non-Indian, they can be wearing the hey, I'm a state police officer hat. And so they've been given that authority under the agreement, which gives them then the right to question, detain, and then even usually under cross-deputization agreements, they can go the extra step of actually arresting, which you couldn't do under the United States versus Cooley argument. And the respondent pointed out that something like 99% of tribes have some cross-deputization agreement with state or federal officials. And so they didn't think there was going to be this gap. There wasn't going to be that serial killer that was getting away. There weren't going to be a bunch of drunk drivers that were driving off. The problem, of course, is, there are tribes that don't have cross-deputization agreements. And we have a great example of that in seeing what can happen here in Minnesota with the Mille Lacs Band. The band had a cross-deputization agreement for a long time, and then a dispute between the band and the county arose with regard to the boundaries of the Mille Lacs Band's reservation. And the county decided it was going to pull out of the cross-deputization agreement, and then threatened tribal police officers that they were going to actually arrest them if tribal police officers were performing their job and detaining, investigating, tribal members or non-members. So everyone, the threat was that the county was going to arrest tribal police officers. So there are always examples like that. And Montana, the Crow tribe, was an example of the tribe did not have a cross-deputization agreement. And the court said that a cross-deputization, that whole area, fine. The fact that the tribes can pursue that, they can pursue that and get additional authority, like the authority to arrest. but it doesn't change the fact that their inherent sovereign powers under the second Montana exception allow them to do this regardless of whether there's a cross-deputization agreement in place. The last point I'll make, and hopefully you guys jump in with a few more questions since I think we have about 10 more minutes or so now, is, in terms of why this is important, this is, as I mentioned, the first US Supreme Court case that finds the second Montana exception satisfied. Now, this is a double-edged sword here in bullet points 1 and 3. So tribes and the United States were arguing, look, Montana in that line of cases doesn't apply at all. Instead, the court hasn't addressed this. And so the starting point should be figuring out, is this within the, that circle of territorial sovereigns? Do they normally have this authority? Yes, a territorial sovereign normally has the ability, their police officers can detain or question anybody within their limits who's under suspicion of having committed a crime. And then the thought was, the argument would be, has this been taken away or implicitly divested? Let's look at historical evidence, which is what was done in the Oliphant versus Suquamish case. Let's look at historical evidence and see if there's any indication that tribes lost this authority after discovery. Did they continue to exercise it? And so there was historical evidence showing that the authority was continued to be exercised. And so both the United States and tribes thought that the argument here was, hey, it hasn't been implicitly divested. This fully exists as far as tribal sovereignty. And it has nothing to do with Montana, since this is criminal and it's executive action. It's a tribal officer and it's not legislative, it's not adjudicatory. The court, though, makes it clear, I think, that it's extending the Montana line of cases again. And when I say extending it, if I can go all the way back to that graphic, Montana started off, sort of kind of taking a little bit from Oliphant in using this implicit divestiture doctrine. And it started when it was looking at civil regulatory jurisdiction of tribes. And then it was on fee land. And then in Strait versus A1 contractors, the court expanded it a little bit more and said, now we're applying this to rights of way and tribal adjudicatory jurisdiction. And then in Nevada versus Hicks, the court went a little bit further and said, okay, now it can sometimes apply on trust land, right? And even when a tribal member is somehow, involved as a litigant, because in that case, the defendants were state officials. And then in, the Plains Commerce Bank case, the court said, okay, and tribes don't have jurisdiction over particular matters that involve fee land. So the court has continued to expand Montana. And by that, I mean this general proposition that tribes don't have inherent sovereign powers over non-members, except if one of the two exceptions applies. So I do think, the cautious way of reading United States versus Cooley is saying that the Supreme Court is now saying the Montana framework, it just applies across the board to everything that involves non-members of the tribe, except you have an even more restrictive reading under Oliphant for actual criminal prosecutions. With that said, though, the glass is half full from the standpoint that we do see an example of the second Montana exception being satisfied. And the court found that this rose to the level, despite the fact that the facts, you read them and you think those are good facts for the tribe. At least I thought they were. There was a little kid in the car. There were guns sitting on the car seat. There were drugs that were fairly visible in plain view. There seems to be a lot of evidence that the driver was actually moving to take a loaded weapon and potentially pointed at the tribal police officer. So all of those were pretty good facts. At the same time, this wasn't, this wasn't a crime of massive proportions that we're talking about. And based on the court's previous precedent, you could have imagined the court sort of downplaying what had occurred here and saying we need to look only at these specific facts, this potential crime, and would this one crime have a catastrophic effect, or would it imperil the health, safety, or welfare of the tribe? And you could have envisioned the court saying no to that. So the fact that the court did say yes in a 9-0 decision that was pretty clear and straightforward, I think is definitely a win for Indian country. So with that, I will stop my share screen and see if anybody has any questions that you would like to ask. One other thing that I can add, to this cross deputization, I mentioned the Mille Lacs example. And the Mille Lacs band, if you're not familiar with it, is currently involved in litigation that's it's up in the 8th Circuit about whether their reservation boundaries remain intact, and they're being supported in that position by the United States, by the state of Minnesota, and it's really only the county at this point that's contending that the Mille Lacs reservation doesn't still exist. There is a mechanism in Minnesota law, of course, for there to be cross deputization agreements between tribes and states, and state police officers. And the Prairie Island Indian community recently, in the past few years, got an amendment to that law that makes it clear that they have the ability to exercise authority even if they don't have an agreement like that in place. So that's worth noting. A question: if the tribe had a more invasive search policy, would the court still uphold that policy? I think no. I mean, what was happening in the questioning was they were making it quite clear that they're kind of putting this into criminal procedure rules they already have. And so this is Terry stop authority, right? This is the authority to say, I have a reasonable suspicion that there's something going on here, and I have the ability to expeditiously ask questions and do what I need to do to try to confirm whether there is or isn't. And so then once I reach the point where I've either dispelled my reasonable suspicion or decided there's probable cause, right? At that point, if there's probable cause, I have the ability to briefly detain and call state or federal officials to intervene. But it's just that Terry stop authority and doesn't allow anything beyond that. Did anybody raise the floodgate argument? Is your sense generally that tribal officers would have let Cooley drive on? No, I don't get the sense that most tribal police officers would have let Mr. Cooley go on. Just from the standpoint of, if you think about it, he had multiple weapons and drugs in plain view with a small child in the car. So I think, kind of regardless of whatever the legal structure was, Mr. Cooley was going to get detained there. And really it's about whether the evidence was going to be excluded or not. But for public safety reasons, I think Mr. Cooley was going to be detained. And it's worth noting that it just always brings me back to, there's a professor at University of Connecticut's Law School, Bethany Berger, who once told a story that would, when she was on the Navajo reservation, and I don't know whether she was specifically telling the story about herself or about somebody that she knew, but I'm going to act like it was her. She was pulled over by a tribal police officer. She's non-Indian. She was pulled over for speeding, and she might have let the tribal police officer know that he couldn't actually give her a ticket for speeding, and she was aware of what the rules were, and that the tribal police officer said to her, "Yeah, that's great. We can sit here and wait for state officials to show up, or you can, recognize that we do have the authority to give you this ticket and pay the ticket and then move on." And state officials were a pretty far distance away. And that, that's the reality on the ground is always quite different from the reality in court opinions. And I think tribes, have routinely exercised this authority, believing that they have the authority to exercise it. And that many non-natives do actually comply, with tribal police officers' direction. And so, in many ways, there is kind of a difference between what the Supreme Court says and what actually happens on the ground. And here, I think, I think this was confirming a practice that's been going on for a long time. We have about 2 minutes left if anybody has a last minute question. Question says, do any tribes have codified search policies that would apply under similar circumstances that go beyond Terry? I don't know of that. Tribes are bound by the Indian Civil Rights Act, which is a federal statute passed in 1968, which says when the tribe's exercising authority, the Bill of Rights doesn't apply directly, so the Fourth Amendment doesn't, but there's a very similar provision in the Indian Civil Rights Act, and most tribes interpret that by looking to federal case law in the first instance. And some tribes have actually codified that in their constitution. And so, typically I think tribes apply that same rule. I do know some tribes that are more protective. So the Menominee tribe in Wisconsin, for example, has much more limited exceptions for the search warrant requirement than the US Constitution has. And so that's part of it's specifically in their constitution and in their laws, they have a more protective view. I don't know of any tribes that view their ability to search more expansively than under the Fourth Amendment. I think I have to stop there. I will say if you're interested, United States versus Cooley, that the Federal Bar Association and the Minnesota American Indian Bar Association are doing a joint CLE that should be happening at some point in October that is likely going to have a panel on Cooley talking specifically more from the in-depth Indian law perspective. So if you're interested in hearing more, that might be a good opportunity to look out for.